The next case is State v. West. Each party will have 15 minutes to present their argument. Counsel, how long would you like to reserve for rebuttal?
Reserve 5 minutes.
You know the court will, we keep the time up here and we'll let you know when you're about 1 minute left in your time at that point. The argument is being recorded. Make sure you please stand behind the podium, introduce yourself, speak in loud voice so we can hear you, and try not to move from the podium area so we can keep recording you. If you are referring to any child, minor, or victim, please make sure you do that with initials or some other terminology like the victim or something to that effect. We've read your brief and are ready to proceed whenever you want.
Yes, may I please accord Giovanna Bremke on behalf of Mr. David West. Mr. West was originally charged with several counts: aggravated burglary, kidnapping, domestic violence, disrupting public service. All of those were dismissed by the state, leaving one remaining count, failure to comply, which he was convicted of and sentenced to 30 months in prison. I've raised two arguments: manifest weight and sufficiency of the evidence. So I will get into the facts just a little bit, but and they aren't complex. It surrounds a case in Lorain, in an area, a bar called Sinners and Saints. And the police were actually familiar with Mr. West from prior uncharged incidences. They went out that night looking for Mr. West, and there were two officers on patrol, and it's Officer Daniel, who claims to identify Mr. West in this incident. The whole issue is identity for manifest weight insufficiency. The officers testified that they saw Mr. West get into his vehicle coming out of that establishment, and that they saw him from a distance. They ended up stopping the vehicle, but it took off, so they weren't able to stop anyone that night. Mr. West, on the other hand, presented a witness by the initials of DC, and she said that she was with Mr. West that day, February 5th, and that she gave, it was her vehicle that they had seen that night, and that she had seen, or that she had given the vehicle to Mr. West's son, whose initials are JS. They actually had charged DC, the witness, with wrongful entrustment, and she said she was confused why they were charging her with wrongful entrustment, because she had given the vehicle to JS, who was a licensed driver, when the police came and spoke with her. As far as sufficiency, again, the argument is that the state failed to present sufficient evidence, that Mr. West was the one who had failed to comply with any sort of police order, which again was the only conviction in this case. The vehicle was not registered to him, and the only identification is that of Officer Daniels, who saw the vehicle from, he said, 50 yards away at 2 a.m. in the dark. And they couldn't see inside the vehicle. There was a tint that was actually darker than would normally be permitted, because there was an allowance for a medical condition. DC had testified to that she had a medical condition which permitted a stronger tint, in addition to it being dark that night. Additionally, I argue in my brief that it was that officer's intent that night to go out and find Mr. West. So it's kind of like confirmation bias argument there. Officer Akers, that was the other officer with Officer Daniels, had testified that he wasn't 100% sure that this was Mr. West. That's transcript page 139. And again, I also have a manifest weight argument that they failed to prove that Mr. West was the individual in that vehicle that night. DC had testified that she gave the vehicle to JS, who's Mr. West's son, and that she was with him on that day. So we would just ask that you reverse the convictions. Thank you.
Thank you. You have a full time for rebuttal.
Thank you.
Good morning, may it please the court, Mark Moza on behalf of Lorain County Prosecutor J.D. Tomlinson. Your Honor, judges, it's correct that there were two officers that night that saw Mr. West in the vehicle. It was Cole Daniel. He had previously stopped Mr. West in that same vehicle, the black Ford Fusion, with the license plate JSY3105 for a DUS OVI suspension a few months prior. They were on alert that night on February 5th that there had been some issues in South Lorain, particularly Saints and Sinners, the bar there. There was a shooting that the police believe David West was involved in. Additionally, Officer Daniel, who was previously familiar with him, saw West exit the bar wearing a long t-shirt that was either red or orange and enter the driver's side of that black Ford Fusion vehicle. Officer Aker, who was not familiar with Mr. West, looked up the BMV video and then confirmed it. There was some issue that would go towards manifest weight argument with regards to Officer Akers, who was also in the vehicle, and the direct testimony was, on cross-examination, your identification of Mr. West wasn't 100% based on your words as far as it should be, and he says you're using my words against him. That was cleaned up on rebuttal that he did say that I 100% identified him as the person that Officer Daniels identified. So additionally, they have this chase through Lorain. It's called off because it's ultimately unsafe to be driving through the roads this way, at this speed, at this hour through residential. And then the next morning, Mr. West arrives at the Lorain Police Department regarding a separate matter, driving the same vehicle, same license plate, wearing a red t-shirt. Additionally, with regards to manifest weight, Denise Carter did testify she entrusted the vehicle to JS, but she also testified that she could not account for Mr. West or where the vehicle was from 9 p.m. that night on February 5th or on that night until 7 a.m. when Mr. West arrived at the police department. I believe, based on some of the case law cited Flynn in these matters, that there's more than enough evidence to meet our burden that Mr. West was the defendant driving the vehicle, and additionally, I don't believe this case is unique enough that there's enough evidence to overturn what the jury heard, as they were presented with inculpatory and exculpatory evidence. Obviously, they believe the inculpatory evidence over the exculpatory. Thank you for your time.
Thank you.
I don't have any additional rebuttal.
All right, thank you very much. The court will take the matter under advisement and issue a decision in due course, and that decision is read to be mailed to you by the clerk of court and also be available on the high Supreme Court limit. With that, I'd like to thank both of you for your presentation.
Thank you, Your Honor.